All right. So it's officially noon. We'll go ahead and get started with introductions today. So I'm attorney Stephanie Bivens here at Bivens Associates, and we're so pleased that you could join us today for this discussion about Arizona's brand new law, creating for the first time something called supported decision-making agreements. And I'm very pleased to be able to introduce to you attorney Megan Selvey here at the firm. Megan's practice includes estate planning, probate, trust administration, elder law, and special needs planning. And Megan has a lot of experience working with families who have loved ones with special needs or any other older individuals that we feel potentially could benefit from this new law. So we're happy to bring this information to you. And Megan, we'll go ahead and let you get started. One quick housekeeping note. If you have questions during our presentation, please use the Q&A feature at the bottom, and you can submit your questions that way, and we will address questions either at the end or as we're going along, wherever it makes space in our presentation today. So sorry, Megan, with that, go ahead and take it away.
Cool, thank you. All right, so our agenda will be, so we've got some slides and we're going to talk through supported decision-making agreements. So I'll share my screen in a second. And I think that'll take maybe around 20, 30 minutes, and then we'll open it up to questions, and please do ask them. We're happy to answer them, and it makes it more interesting. So go ahead and don't be shy. So we'll get started. And Steph, you can see the slide screen, right?
Yes.
Okay, cool. All right, so I labeled this 5 things to know about supported decision-making agreements. You know, nowadays, if it's not in a bullet point or numerical list, I can't read it. So maybe that's true for all of you too. So we're going to try and break it down into a couple different things. And then, you know, if you're on this webinar, you probably are familiar with our firm, but just in case you're not, just a little bit about us. This area of law is all we practice in. So we kind of stay in our lane. We're, you know, I think really good at what we do. So it's all estate planning, probate, trust administration, elder law, and special needs. So we don't practice in other areas. We're happy to work with other attorneys in those areas. But if you are in need of any help in those categories, you know, let us know. And we're happy. I have to give the firm a little shout out. So for 2023, we were named recognized for estate planning and elder law for Ranking Arizona. So that was nice as well. All right, so what is a supported decision-making agreement? So this is a new law that the governor signed, and it will take effect 90 days after the close of the 2023 session. And Stephanie and I were just talking this morning that apparently the legislative session for 2023 is running a little bit longer than they typically run. So, you know, I think they're anticipating being done end of July or perhaps early August, but the effective date of the legislation would be 90 days after they close. So supported decision-making agreements, it's a new concept in Arizona, but other states have implemented this already. It's not a nationally adopted concept at this point. And guardianship and conservatorship laws and trust and estate laws vary state by state anyway. So it makes sense that states would opt in and adopt this as they feel it's appropriate for their population. So we're going to talk about what it is in Arizona, or what we think it's going to be. Obviously, it's not implemented into practice yet. So this will be, you know, the point of this webinar is just to give an introduction to this concept and also to hopefully distinguish it from what guardianship does or what a power of attorney can do. So we're going to talk a little bit about that. But I fully expect after the law goes into effect and we're seeing this incorporated into, you know, real people's lives and it's in practice, like maybe we'll do some sort of update to kind of, elaborate on the nuances that we discover once we're in practice. So, all right, number 5 thing that we want to know is why this? Like, what are the goals of a supported decision-making agreement? What was the point of enacting this legislation? So for a long time, it seems like there's been a gap in what a power of attorney can provide for someone versus what guardianship provides. And I think a lot of families were looking for something that would provide sort of a solution that's in the middle. And, the supported decision-making agreement, what it is it's a tool that we can work with now. So it's just another potential solution for people, but it is a different concept altogether than guardianship. So the point of the agreement is that there's an adult who's entering into an agreement with a supporter, and the agreement and the role of a supporter will helpfully make the adult help them understand information and help them make choices about their own lives, like where they live, how to understand their finances, how to understand medical care, helping them with education or jobs or resources or interacting with the community, all of that. So the point is to try and promote self-determination and independence, and hopefully provide some sort of support that enables this person to retain their legal independence. It really is what it is. So with that goal in mind, let's kind of talk about how we think the agreements are going to shake out in reality. So the agreement, which I'm going to call an SDMA, supported decision-making agreement, will allow an adult, they have to be age 18 or older, to enter into the agreement. And the agreement's really a contract. So it's a written document. The support person, we're just going to call supporter, also has to be an adult. So they have to be age 18 or older. And then the adult is going to, in the agreement, will authorize the supporter to do things like provide supported decision-making, including assisting the adult with understanding options, responsibilities, consequences of life decisions without making those decisions on their behalf. So that person's role is really to try and help gather and distill information so that the adult can have a close resource at hand to try and make good, sound, independent decisions. The other thing the supporter should be able to do would be to assist the adult in accessing, collecting, and obtaining information that is relevant to the decision that they're trying to make, be it medical, psychological, financial, educational. I want to say a couple things about that. So I mentioned at the beginning, this is a concept that is new to Arizona, and supported decision-making agreements they're implemented in other states, but not all states, right? This is not a national, adoption of this concept. So if you've got entities, like third-party entities, be it, let's pick on a financial institution. The financial institution may or may not be familiar with Arizona's laws. And if presented with a supported decision-making agreement, a financial institution may or may not recognize the supporter's authority in gathering financial information. So we're going to come back to that. But, that's one thing that remains, that's like an example of something that sort of remains to be seen how it may be treated in reality. But that is actually one of the goals of the agreement, would be the supporter is authorized to help with that kind of, information gathering to try and bring information to the adult and help them process it so that the independent decision can be made by the adult themselves. And assist the adult in understanding the information listed above, and assist the adult in communicating the adult's decision to appropriate third parties. So that's another thing, right? Is that, we're trying to facilitate the independence of the adult. So if that means, it kind of helping them obtain information, process it, and then once the adult has made independent decisions about things, to the extent that there needs to be help communicating those decisions to third parties, that would hopefully be something the supporter, would be willing to do and is agreeing to do here. So, basically the supporter is trying to just help the adult, act independently, retain independence, so that there doesn't need to be a legal intervention to appoint a different decision maker. But the decision making for the adult has to be like theirs and theirs alone. So we'll come back to that. Okay, so what can't a supporter do? So they're not a surrogate decision maker. They are not a legal decision maker. So, they're maybe in a financial context, maybe they're gathering information, gathering account balances, helping the adult communicate with a financial institution, but they are not the ones saying, okay, move funds, or okay, distribute funds here, or they're not making any decisions. They don't have authority to sign legal documents on behalf of the adult, and they don't have the authority to bind the adult in a legal agreement. These are all things that maybe they're helping the adult, again, gather information to make the independent decision themselves, but they are not a decision maker. The legislation clearly states that a supporter that intimidates or deceives the adult into gaining the supported decision-making agreement or any other authority provided in the supported decision-making agreement to criminal prosecution and civil penalties. So the supporter is liable if they are trying to, take any bad action or coerce the adult into trying to sign an agreement and gain decision-making authority where they don't have it. They're prohibited, the supporter is prohibited from receiving compensation. So this is different than guardianship and power of attorney, because, if authorized, a guardian or an agent under power of attorney can receive compensation. So this is sort of a notable difference. Supporters should not be receiving compensation as a result of their duties. So just to summarize here, the supporter clearly cannot make decisions. They should be acting in the adult's best interest. They should not be deceiving or coercing, intimidating to try and gain a certain result, and they shouldn't be receiving compensation. Okay, and then what is in the supported decision-making agreement? So the agreement itself should explain rights, roles, duties, and limitations and obligations of the adult and the supporter. The agreement should be signed by the adult and the supporter. It says in the presence of 2 or more witnesses who are 18 years or older, so obviously adult witnesses, or a notary public. Certainly, it wouldn't hurt probably to have it witnessed and notarized. That's my suspicion would be if drafted by a law firm that would be how it would be handled. And then states that a supported decision-making agreement extends until it's terminated in writing by either party, the adult becomes incapacitated, or a guardian is appointed for the adult. So the decision-making role only applies while you've got a competent adult who is alive and does not have a court-appointed guardian. Frankly, I would think the agreement would also terminate if the supporter became incapacitated or had a guardian or passed away. So, and then finally, I've mentioned this, and we're going to spend some time now talking about this. The supported decision-making agreement does not replace what I'm calling other measures. So, very clearly, someone who's legally incapacitated could not execute a supported decision-making agreement. So someone who meets the Arizona legal standard for incapacity, really that's when guardianship is appropriate, potentially. So meaning that there is, a cognitive element where someone is unable to make or communicate rational decisions regarding their health and well-being, right? So if someone is not, does not have legal capacity under that definition, and they never have, so there's no existing power of attorney that would allow a decision maker to help them, then that would probably still be an instance where guardianship would be appropriate. So just to refresh, guardianship appoints someone to handle decisions regarding health and well-being and where someone lives and things like that. Conservatorship is appointing someone to manage finances. It could be the same person or entity. Sometimes it's different. So really, let's take a case where someone does not have legal capacity and they have never had legal capacity after age 18. So there was never any opportunity for that person to sign a power of attorney to appoint a helper. If someone needs to have authority to make decisions regarding that person's healthcare, living arrangements, things like that, I think that, that family is likely still in a position where they're going to be petitioning the court in Arizona for guardianship. Where I see a supported decision-making agreement be really helpful would be in a scenario where someone is age 18 or older and they do have legal capacity. So they have the ability to cognitively make and understand decisions regarding their well-being. However, maybe they have trouble communicating those decisions to third parties, or maybe they have trouble, interacting with third parties to get, information from third parties, or just kind of, navigating the different systems that we have in place in society. That would be a wonderful use of a supported decision-making agreement, right? A competent adult can appoint a supporter so that there's a designated person that has undertaken that responsibility to try and gather, distill information, help them understand whatever needs understanding to make decisions, and then help them communicate those decisions to the world around them so that they can independently move about and function in society. I think that it could also be really helpful under those circumstances for the adult signing the supported decision-making agreement to have powers of attorney in place also. Back to my example about a financial institution that maybe operates nationally and is not very familiar with Arizona law, right? Financial institutions in particular are going to be really used to seeing powers of attorney. They're going to be used to the concept of a power of attorney. And there's statutory, there are laws in place defining the role of an agent under power of attorney and defining when they're liable for decisions or not, so those are all important components to consider as part of this. So I think powers of attorney could be really helpful for a competent adult who's entering into a supported decision-making agreement to also at the same time have a healthcare decision maker named. So if later they lose competency or they're not awake, they're in surgery under anesthesia, right? There's also a named healthcare decision maker. And then their healthcare wishes are outlined in writing as well. That's a living will. And then there's a general power of attorney, meaning it pertains to their financial matters. So that like if someone is trying to help them with financial matters, there's also that authority under power of attorney. I just think it could be helpful. And just a reminder for anyone who is, powers of attorney are a good idea for every adult who is competent to sign them over age 18. It's always good to name, have a rainy day plan, right? So if something happens to you, you've got your decision makers already named and valid legal documents, your wishes are stated in writing, it eliminates confusion. And then a general power of attorney, it's a good idea. When someone signs a financial power of attorney, they always get to decide when that authority is effective. So if I sign a power of attorney and I'm naming Stephanie as my agent, I get to decide if her authority as my helper under power of attorney begins at that time I'm signing it, or if she has to wait until a physician or two physicians, sign something in writing saying Megan's no longer competent to manage financial affairs. So, if someone's worried about giving away authority at that moment, they don't have to. They can make sure it's only effective upon incapacity, but if it's effective immediately, allow someone to help them immediately. So,
Megan, there was a good question posted in the Q&A asking, does power of attorney have an expiration date? So do you maybe want to elaborate on that?
Sure. Often we draft powers of attorney to be durable, meaning that a durable power of attorney is effective until it's revoked or until the principal, so the person signing it, passes away. If the principal who's signing the power of attorney has a different vision for when they want it to last, certainly that can be drafted, but I would say the vast majority, almost every power of attorney that comes across our desk is durable. Would you agree with that?
Yeah, the only time you would have a set end date is if it was going to be for a specific task, like
or maybe like
real estate closing or something like that.
Like I'm thinking if you were going to be traveling internationally and there was something very specific you wanted something to do. So it doesn't have to be durable, but usually it is because people kind of want to get it done and then it's done until they change their mind, in which case you'd revoke it. So.
Right. Just had another question too. It's an interesting question. Could someone have a trust that assigns someone as the trustee, but requires them, I'm assuming it means requires the trustee to use an SDMA that would help the trustee, but not place any obligation on them? I'm not sure. The interesting thing is that with regard, I'll kind of take a stab at this answer and Megan, see if you feel the same way. The trustee has to follow the terms of the trust. I think it would be a really unusual provision in the trust to mandate that the trustee designate a supported decision maker in the capacity as trustee. I think we actually have something else in the law called a trust protector that might help fulfill that role. It might just be crossing lines a little bit. but
Yeah, I completely agree. And then the other thing is that I think the SDMA legislation is pretty clear that the agreement has to be signed by adult and supporter. So it would, like in the scenario as asked, assign someone as trustee, but requires them to use an SDMA. So I just like a trustee could not enter in to an SDMA. Like it's up to the adult to
right.
decide who their supporter is, and like maybe they don't want the if they do want the trustee and it's the same person, fabulous. But if they don't, you couldn't force it on them like per the terms of the trust.
Yeah. So another question here. Thank you guys for the questions. These are great. You mentioned that a supported decision-making supporter can't benefit financially. Does that mean a parent cannot provide habilitation or attendant care services to their own adult child if they are also their SDMA supporter?
So again, like the law is going to be kind of fleshed out in practice once it goes into effect, but my gut reaction here is no, that's not the intent of saying that that supporter can't be compensated. I think it's more like, so if a power of attorney says my agent can receive compensation, the agent is keeping track of their time, right? So like if I name Stephanie as my power of attorney and she's like, okay, I gotta call the title company and see how about, titling the terms of the sale of the house or something like that. She's keeping track of her time. 7 minutes on the phone with the title company, half an hour at the signing closing docs, and then she's compensating herself a reasonable, or however the power of attorney prescribes, but usually it says a reasonable compensation. So that's like a reasonable hourly rate based on the time she spent helping. That's how compensation's like generally working for a power of attorney or really even a trust. So here, but in the legislation saying a supporter can't charge compensation, I think that what it's saying is a supporter can't do something like that. They can't keep track of their time and compensate themselves for time spent being a supporter. Now, I think in practice, a lot of families are going to wind up having, a responsible adult sibling or a parent or a family member as the supporter. I think that's how it's probably going to play out. And I would absolutely expect parents to often be providing some sort of, housing maybe to an adult child who needs, who's an independent adult, but we're going to utilize the SDMA. And so there might be like a interplay there where like parents are getting rent or something like, I think that that's going to be normal. And as long as they're not charging for their time as the supporter, they're probably not going to be running afoul of the statute.
Yeah, I think attendant care services, habilitation, which are the two specific services mentioned in the question, are very specific services for care that are very distinct from the concept of supporting somebody in decision making. So I don't think, this SDMA prohibition for compensation would mean now a parent can't get habilitation or attendant care services provided. I think it's like apples and orange when you compare the services. So I think parents will still be okay.
Yeah.
So another question here, Megan, and this is just kind of a commentary on financial powers of attorney. I think circling back to the answer on, how often you have to refresh or how long is a power of attorney good for? Somebody commented, some financial institutions require an updated power of attorney after 5 years. And yes, that's consistent with what we say and with what we see. So when Megan uses the term durable financial power of attorney, durable by statute means it's good until the person who signed the power of attorney dies or they revoke that document. So technically the law says this power of attorney is good and the person named has the authority until they don't anymore. But in the real world, if you take a 10-year-old power of attorney that's never been authenticated to the bank and you attempt to use that to sign checks and assist with somebody else's account, the bank may want a fresher dated power of attorney or some assurances that that older document is still in full force and effect. So good rule of thumb is, if possible, update that power of attorney every 5 years so you just don't end up in, you know, a long review process with the legal department at the bank trying to get it honored. That's just sort of good practice. So thank you too.
I think that comment further underscores the point that, you know, the concept of a power of attorney is a well-established legal concept. And yet banks will still very closely parse the language of a power of attorney. They will look at the notary section. They will look at the witnesses. They will, you know, like a bank legal department will just thoroughly review a power of attorney and they will reject it at their discretion. If they think that it's, you know, like outdated or signed wrong or something like that. So even with a very well-established concept like power of attorney, it can still be a little bit of, you know, a tug and pull dealing with banks. And so that's why we're saying with a new concept, like a supported decision-making agreement, I mean, even though Arizona law says the supporter should be able to help gather financial information, I think it's not out of the realm of possibility that you're going to get some pushback from banks going, okay, we don't understand this as a concept, or we don't recognize this, or that's great, thank you for showing us this. We'd also like to see a power of attorney. You know, I think all of those things are possible.
Yeah. So there's another question, and I think we kind of started answering it, Megan, with your last comments. Could you please expand the general power of attorney? Does this mean for health, finances, mental health? So I'll kind of answer in general. You know, Megan and I will use the terms power of attorney as a general umbrella term, but there are different types of powers of attorney. So in Arizona, we have a durable financial power of attorney. So that's the type of power of attorney Megan was just describing about the document that we've given to the bank, for example. It deals with just granting the agent under the power, durable financial power of attorney, the ability to handle somebody's financial and business matters. Has nothing to do with medical decision-making or personal decision-making. In Arizona, we have a suite of medical directives. We have a healthcare power of attorney that designates someone to make medical decisions when the patient is unable to communicate and make their own medical decisions. We have a mental health power of attorney, which is unique, and it authorizes the agent to consent to psychiatric care and treatment, particularly and uniquely for inpatient hospital psychiatric level treatment. And then with medical directives, we also have a living will, and then I would throw the DNR, do not resuscitate order, which most people don't have, and then also a medical release, which I think everybody should have. So those are like the different types of documents that you see. All of those documents combined with a will and a trust are part of an overall comprehensive estate plan, which goes beyond the topic for today. But because SDMAs are unique to powers of attorney, we have to make sure that people understand that the distinctions. And so this gets to somebody else's comment, says, I'm not sure I understand why you would choose the SDMA versus a POA. And I think, you know, Megan's point is it's not one or the other. It's probably both or none. Is probably more the thought process. Yeah. So Megan, if you maybe want to discuss a little bit and unpack a little further, you know, the fact that the agent or the power of attorney has legal authority to act, make decisions, whereas the SDMA does not. I think that's where people are that's where everybody is gonna get tripped up on this, the differences between the two.
Yeah. So I mean, I think it's helpful to also understand like the context of why, you know, supported decision-making exists. I briefly mentioned this at the beginning, and, you know, I think that there has been a desire to have some sort of alternative to guardianship for, you know, some time. The reality being, though, from like a legal perspective, I'm going to speak from a legal perspective, that, you know, the law clearly gives us a definition of when someone has capacity to make decisions and when they don't. So if I do not have capacity to make decisions, like cognitively, I'm not able to make safe decisions regarding my well-being. If I have a power of attorney that I signed while I was still competent, and it says, great, my friend Stephanie can make all my decisions, right? She can make my healthcare decisions, and I've given her financial power of attorney. So I'm pretty much covered, even though I am not capable at this moment. Hopefully we can still avoid guardianship and conservatorship for me, because I already, when competent, appointed a decision maker. So she has the legal tools to step in and help me. For someone that doesn't have powers of attorney, or that like perhaps they just never did it, or maybe they could have never done it because they never had capacity to sign those documents ever. You know, if they can't make their own decisions and there's no other legal alternative, there's no other power of attorney in place to make decisions, I mean, that's why guardianship exists. It's a really, you know, from a legal perspective, if someone lacks capacity and there's no other legal way we can get decisions made, I mean, you're facing guardianship. That's the reality of it. So there has been a desire for a long time for individuals that, you know, don't meet that legal standard of incapacity. So someone who's competent, who's maybe like could really benefit from assistance and, like I said, moving about the world, communicating with the world, you know, communicating their own independent decisions. You know, and that's what the supported decision-making agreement is trying to solve. They're trying to give someone who maybe is struggling to like interact, you know, or get their independent voice recognized by third parties, an alternate way to try and help them, you know, live independently. But it's just difficult because, you know, the incapacity standard is met or it's not. So there is no, this, you know, supported decision-making is not, it's not guardianship light, right? Like it's not for someone who is incapacitated, but would like to avoid guardianship. That's not what it is. A supported decision-making agreement is for a competent adult to sign and appoint a designated person to be their supporter. And I think that it's still a helpful concept, because then you've got the supporter who is understanding, like, I'm going to be relied upon. I'm the person, I'm undertaking this responsibility, and I am willing to be there along the way to make, you know, decision-making easier for this independent person. So, you know, I don't think that it's, you know, to the comment that was just like, why not just a power of attorney? I still think this could be really useful. Like I said at the beginning, another useful tool in the canon for people. But I think power of attorney, you know, especially financial power of attorney in conjunction with a supported decision-making agreement will be probably the better way to go than just only a supported decision-making agreement, because power of attorney is going to be more regularly recognized by third parties. So I don't know. Stephanie, do you have anything to add to that?
I think the most obvious population that is going to be helped by having not only healthcare power of attorney, mental health power of attorney, durable financial power of attorney, the healthcare documents allow somebody else to engage in medical decision making when the patient becomes incapacitated. But there's the gray zone, right? There's the in between. So I think the population that may have some of those in between phases are going to be individuals with developmental disabilities, somebody maybe Down syndrome, on the autism spectrum, or some other type of cognitive impairment where they are able to participate and communicate with a physician. So they are actually legally competent and they're making their own decisions, but in a high stress situation, when presented with a complex medical decision, and they are expected to give informed consent, understanding the burdens, the ups, the downs, the risks associated with some complex medical decision making. I think, for that population, these SDMAs could be particularly useful. And this legislation was really initiated through the efforts of persons who support the younger population, persons with special needs, younger individuals with disabilities. But since Megan and I are also elder law attorneys, and we work with a lot of families who either our clients or our clients' loved ones have progressive cognitive impairment illnesses like dementia, Alzheimer's, Lewy body syndrome, some other things in the elderly population, I think this can be equally beneficial in that population as well, because we're starting from a point of maybe early onset Alzheimer's or dementia. And as this individual becomes less and less able to give informed consent, they become less and less consistent in their judgment, in their ability to recall and remember information that doctors are telling them, yet they're still making their own decisions because they're verbal and they've not been declared incapacitated. They don't meet that standard. I think both ends of that population are potentially the groups of folks that are going to benefit from this the most. If Megan and I were sitting down and meeting with somebody who wasn't in that population, I'll say, a typical individual, just kind of using industry jargon there. I don't know that anybody is typical, but using a typical individual, just using regular estate planning documents without the SDMA is probably the path they would go. I don't think SDMAs are for everyone. And we're not saying they're for everyone, but in certain situations, I think they, as Megan has said, would be very useful. So, it's just interesting that this is a brand new concept. We're going to see how this plays out in the real world. What is going to happen at the hospital social work team meeting when the patient's in the hospital and their sibling shows up with an SDMA? Is the hospital going to communicate with them? How well are they going to communicate? I just think it's just going to, like everything else, there's the legislation and there's what's intended, and then there's what happens in the real world with it and how effective is it. I think we'll see that, but I'm encouraged. I think this is, as Megan has said, it's going to be a useful tool in specific circumstances for families. And the more tools we can offer to families so they can better support their loved one who needs support, fantastic. That this is just one more tool in the toolkit. And Megan, I'm going to circle back to a question because it's a good question. I want to make sure we answer this, and then I have a few more comments too that we'll have you elaborate on. But the question is, if a guardianship was given to a young adult, is it easy to end it and move into an SDMA with a power of attorney if that young adult later could make decisions when helped? So maybe talk about how we get out of a guardianship if we're already in a guardianship.
Yeah. So I think the key there is if the adult can now make decisions. So again, and I think my next slide, yeah. So I did at least have the foresight to copy and paste Arizona's legal definition of capacity because it may help us here. So Arizona law says if somebody is impaired by reason of mental illness, deficiency, disorder, physical illness or disability, chronic use of drugs, intoxication, or other cause except minority, meaning under 18, to the extent he lacks sufficient understanding or capacity to make or communicate responsible decisions regarding his person. It's such a mouthful, but the concept is really there's something going on cognitively that is impacting sufficient understanding to make responsible decisions regarding your person. If that is true, then if that remains true, I don't think a court would terminate guardianship. If the court was presented with evidence that, medical evidence that this is no longer the case, right? This standard of capacity is no longer met. Somebody could have sufficient understanding or capacity to make responsible decisions regarding their person, then, we petition the court, we provide the court evidence, there is a hearing, interested parties, so maybe that's parents or adult siblings or adult children, whoever it may be, are provided notice of the hearing so that they can weigh in, and the court will make a decision. And certainly if the standard of capacity has been proved to no longer be met, then the court could terminate the guardianship. And we have been a part of those hearings. In fact, I heard one judicial officer refer to it as the happiest day that there is in court. And certainly that's the case, right? Because it means someone's doing really well and they're going to be given back independent decision-making from the court. In that case, I think, if that person still could really benefit from having a designated supporter who can help them communicate their independent decisions to the world around them, then an SDMA could be a great idea. I think I've made myself transparent enough at this point that, my perspective is probably a power of attorney is going to also be appropriate. But, I think it just all boils down to, is the standard of capacity met or unmet, right? And that is not determined by your friendly neighborhood elder law attorney. That's determined by that person's physician.
Yeah, the court ultimate, but
Yeah.
the physician's testimony is going to be very compelling. And we have a very high standard to prove incapacity or the capacity is now been restored. We have to prove by a preponderance of the evidence that this individual lacks capacity or is now has regained capacity. So it is nothing that the court takes lightly in making these decisions.
Yeah.
So a couple of other powers of attorney. Megan, keep going.
Yeah,
You're going to answer the question I was going to ask.
I was just going to make sure I didn't have any other helpful slides. So all I did was kind of just summarize powers of attorney that existed in Arizona, but Stephanie already did that verbally on the webinar as well. But in Arizona, just don't forget, we've got healthcare power of attorney and mental health. That's appointing a decision maker who carries out your wishes, not their wishes for you, but your wishes for you, if you are unable to make or communicate your own decisions. So, if you're in surgery under anesthesia, obviously you're not communicating with anyone at that moment. If you've got advanced Alzheimer's, very likely your healthcare power of attorney is communicating decisions at that point. And then a financial or, what we call a general power of attorney, appointing someone who can help manage financial matters in your own name. And then you decide when it's effective, now or upon your incapacity. Yeah.
So a couple of other quick things. We had some questions presented to us actually before the webinar, and I want to make sure we address these. One of the questions is there a specific document to be completed? Is there a standardized form for this?
I mean, the legislature, to their credit, they gave us a template for supporter decision-making agreements. So like legislatively, there is now a template to go off of. And then, they gave witness and notary requirements as well, and kind of the basics that need to be in an agreement. So there's that. I think, lawyers being lawyers may expand upon the template language, and especially as this evolves in practice, right? Like if we see things that are helpful, or like third parties are responding well to this language versus that language, maybe it gets tweaked over time. We are going to have them drafted and ready to go when the law takes effect. I'm sure that there will be like I would imagine there will be, versions people could find not going through the use of a law firm. It can be really helpful to be getting pertinent legal advice on these topics, because these are very serious topics that help someone, and making sure that there's sufficient understanding of what's being signed before someone signs it is always a concern with vulnerable populations, something we see all the time. So I think it's a really good idea to go through lawyers who understand what this is. It's a legal contract. So
Right. And is there anything in the statute that limits one person to being the supporter, or could we have, multiple supporters, let's say mom and dad, or brother and sister?
So my understanding is that it's adult and supporter.
So you could have, as long as they're an adult, at least one, maybe more supporters?
I guess I'm going to admit that I don't quite know. My understanding is that it's the adult, like the competent adult, and then they're naming a supporter.
Okay, so one supporter.
Yeah.
What the statute refers to.
Yes, that's what statute refers to.
Okay. And the statute enumerates a number of areas in which the supporter can assist in decision making, and I think that was on one of your first slides. Do you think that the agreement could be limited to just say one or two areas? Maybe the adult only feels they want help in education and medical decision making, but not finances or other areas. Could you pick and choose among those areas?
Absolutely. And why not, right? So it's just like any contract or any power of attorney, right? So when we draft a power of attorney, we review them section by section with clients, and I've got clients that are like, oh no, this has to go. This paragraph is not, I'm not okay with that, So before you sign anything, you should review it, and we could nix anything that you're not comfortable with. So the adult should not agree to be receiving support on a matter where they don't want support. So.
Okay. And then one more question in the Q&A here. Is there information available, such as links, books, etc., about how to find out if a person has gained capacity to make their own decisions? I know what my answer would be, but I want to hear your answer, Megan.
I would, if this was a client of mine asking this question, I would say the conversation needs to be happening with the physician.
Yeah.
Aside from reading and rereading and then reading again, the standard of capacity in Arizona, I think there's got to be a conversation with the medical team about, okay, here's what's going on with the patient. With that, your evaluation or whatever tests need to be done, or, can you opine on whether they meet the standard or they don't?
Yeah.
And that's what the court is going to want anyways.
Yeah.
They want the-
In my experience, the primary care physician may or may not be comfortable in rendering that opinion based on the length of history they've been treating the patient, their area of specialty, their personal medical practice, standards. So oftentimes we'll end up retaining the services of a neuropsychiatrist or a neuropsychologist to engage in hours-long battery of cognitive testing and assessment to really get a very clear understanding in all of the areas of executive functioning. What areas does this individual have strengths, and what areas may this individual still have weaknesses, and how do those strengths and weaknesses play out in the real world for this person's ability to make and communicate, responsible decisions concerning their personal well-being. So sometimes we'll end up bringing in a medical expert that can do the assessment and help the family and the patient make that determination, and then we can take that to the court as well. So if that helps, I mean, there's no just check the box and we're good. Every single individual is different, and every court case is different, and the judge is going to want to see information specifically related to that patient, and very detailed information related to that patient. So let me check and see if we have any other questions. One more says, if
Thinking that means POA.
maybe, yeah, if power of attorney is someone other than spouse, can a spouse override the power of attorney? That is a great question. Megan, what is the answer?
No. The other thing I'm thinking is I'm going to answer this question as if they meant supporter and as agent under power of attorney. I'll give you my both answers. So if, in my example, where I have been saying I'm going to name Stephanie as my power of attorney, I happen to be married, right? So my husband cannot override that decision, right? Anecdotally, he is my power of attorney, not Stephanie, but we're just hypotheticals here. If you've got a competent adult who has signed a power of attorney and named an agent, I mean, that is their decision, and it is their, at their discretion who they want to name. If you've got an adult, let's say a young adult who names a supporter, and there is maybe divorced parents, and young adult names one parent as supporter and they do not name another parent, and that causes tension or conflict. So much of this, I feel kind of bad because it's just like, this isn't effective yet. We haven't seen it in practice yet. I don't know how this is going to be incorporated into tense situations like that. But, I guess I'll just spot the same issue that this person is spotting, is that I think that could be a source of tension. So I'm going to leave it at that.
Thank you, Megan.
Yeah.
So we're just about at time. I don't know if anybody has any more questions. We might have time for one more if you want to type it in very quickly. We do really appreciate everybody attending this webinar today. Hopefully you've gained some more information about what an SDMA is, probably even more importantly, what an SDMA is not, so that you can spot whether this would be something you think would benefit, your family or others that you may work with or know. We do have a little poll question. So with our last minute here, if you want to answer our poll, yes or no, do you believe an SDMA would be beneficial for you? And we'll leave this open for just a minute. And this is more for Megan and I just being curious as to the audience. And again, these are not going to be beneficial in every situation. But we're just kind of curious. So I'm going to go ahead and wait one more second here. We've got a few more answers coming in. And the yeses were leading, the no's are gaining. I'm going to leave it one more second here. We hit 1 o'clock, so I'll end the poll. So right now, with those that have answered, we're at 58% of responders answered yes. They do believe an SDMA would be beneficial for them. And 42% have answered no, that they don't. So thank you, everybody. And I will share results here just so you can see them really quick. And, you know, we're going to be hosting more educational events upcoming, so stay tuned. We've got lots of webinars coming up on different types of special needs trust, estate planning in general, some other topics that we feel would be beneficial for folks to have a little bit better understanding on. Our thought process is with better information, families can make better decisions, and that always leads to better outcomes. So we're here to share information. Stay connected, follow us on Instagram, all the good social media, you know, our email newsletters. If there are topics that you would like to learn more about in the future, please feel free to shoot Megan an email or shoot me an email and propose some topics. We're here to serve the community, and we want to make sure we're answering the right questions and bringing value. So with that, we will sign off. Thank you very much to everybody for attending. And Megan, thank you for presenting. As always, your information is excellent and useful and understandable.
Hi, everyone. Thank you so much.
Thank you. Bye-bye.